So obviously the first decision that the court had to make was whether our appeal had some merit before it can grant a stay, or else the court would have dismissed our appeal very early this morning. Fortunately, based upon the submissions made, the court had made a preliminary conclusion that our appeal has merit and is worthy of a stay being granted at this stage while the judges hand down the decision in the appeal itself. So, in that interregnum, the court adjourned the matter to tomorrow, 11 a.m., and has ordered a stay of Justice Holder's proceedings, which was supposed to resume at 1:30 this afternoon. So obviously we will not resume this afternoon 1:30. We will await and see whether the full court um, accepts our appeal and takes the matter away from Holder, because that is what the essence of the appeal is, that Justice Holder cannot hear and determine the matter because Justice Holder and indeed the High Court has no jurisdiction to enter into an inquiry into the courts, into the GECOM's decision. Shockingly, you hear Dr. Alexis argue that GECOM never made a decision, but they are challenging that very decision. The decision being the decision to do the recount. The whole plank of the Yolita Moore case is that that decision of GECOM was not validly made because it was influenced by the CARICOM brokered arrangement, and it was therefore not a decision of GECOM but a decision of CARICOM, and CARICOM cannot usurp the functions of GECOM. That is their case. Now they are disputing that that is their case. So the litigation is unfolding in a very interesting way, and if I may be permitted to say, I think we have a good, very, very good case and good prospects of success. The grounds of the appeal are really manifold. They are in essence that Article Section 140, I keep saying article, Section 141 of the Representation of the People's Act, a section that has never been considered before by the judiciary in Guyana, based upon my research, prohibits the High Court from inquiring into any decisions or omissions or acts of GECOM other than by way of an elections petition. What that means is that other than after the declaration of the results, because the election petition comes only after the declaration of the results. My reasoning is that that provision was specifically put there because Parliament wants GECOM to complete the electoral process, and that is why Parliament has conferred upon GECOM a panoply of powers expressed in Section 161(2) of the Constitution, as well as Section 22 and Section 19 of the Election Laws Amendment Act. If you read those sections and that article in the Constitution, you will see a huge plenitude of power vested in GECOM to do almost anything relevant, expedient, and necessary to bring a fair and smooth conclusion to the elections so that the accurate results can be declared reflecting the will of the electorate cast at the ballot.